Hi, everyone. This is Sarah Barker with Connect Our Elders. Thank you for joining us today. And today I'm super excited to have Danielle Barger of Barger and Battiest law firm. She actually started your law firm how long ago now, Danielle?
January 13th, so just this year.
Okay, but she's been practicing in the area of estate planning for quite some time now. So why don't you get started and tell us about why you do the type of work that you do, Danielle, and some about your firm and who you are as a person.
Thanks for having me, Sarah. I'm really excited to be here. So again, I'm Danielle Barger, and I've been practicing in estate planning, trust, and probate law for about 13 years now. Between my partner and I, we do a lot of work with just the planning, administering estates when somebody passes away, troubleshooting, and then a little bit of business formation as well. I got into this area, actually, I was somebody that was in big pharma and I was doing clinical research all during law school. And I intended to stay in that world. I loved it. And unfortunately, my father got really sick in my second year of law school. And in that particular semester, I was taking a class on trusts. And I would visit him every day in the hospital, and I would kind of explain what was going on. And I remember spring break was coming up, and I said, "You know what, Dad, you got to get a trust. Like, this is a really important thing that we got to handle. You're getting out of here next week. We're going to go see a trust attorney." And that was the plan. And unfortunately, the morning I was supposed to take him home, he had a stroke and he passed away, and he left a mess. I had to deal with all kinds of stuff. He wasn't really a rule follower. And so he had not permitted the building on his house that he had done. He had, a lot of older people, they collect coins.
Yeah.
He collected coins, but he collected those ones that you order in the middle of the night from like Home Shopping Network. And so they were mixed with some good ones and some junky ones. And I just had to go through all that, and it was a big hassle. And so I decided to start my own firm right after graduation to help other families not have to go through what I went through. So I really enjoy helping through that process. And that's why I do what I do.
I think that it's I don't want to say that it's super common, but usually when you meet somebody that practices in the area of law that you do, it's what I've noticed, it's one of two reasons, right? They either were in some sort of litigation area of the law and they got burnt out and decided I can't do this anymore, or they had a personal experience that made them realize the importance of doing this planning. And I always think it's wonderful when the person can come from that emotional aspect when they bring that into their work, because this isn't just a job for you. You're coming from experience of, hey, I want to prevent you from going through this really stressful, painful situation that I had to go through. So I think that's great. Let's start with our first question. Danielle, can you tell us what the differences are between a trust, a will, and a power of attorney?
So that is a very common question, and I get a lot of people that mix up the terms. And so I wanted to kind of set the record straight and go over that. Most people know what a will is. A will is a document that says, I leave everything, to my son, Bob, and I want him to be the executor. And in many states, except California, that is the prominent planning document, right? And so I think you're sitting over in Tennessee today, Sarah.
I am in Tennessee.
That's generally what you would do. The problem with a will in California is a will has to go through a process called probate. And probate is essentially filing a lawsuit with your own money to protect your disgruntled heirs and all the creditors. And the pleasure of going through probate in California takes at least a year and generally costs about 4% of the fair market value of the estate. So what happens, you think mom did a great job and she wrote a will and she passes away. So you come to me and you go, okay, what do I do? And I go, well, you can't do anything until the court appoints you as an executor. And that process generally is about 3 months out. With COVID, it's even longer because I had a lot of delays and so forth in the court system. And then you can't really do anything without getting the okay of everybody. So instead of planning primarily through a will, a better way to plan, especially in California, is through a trust. A trust is a separate document that you basically create and you draft the instruction manual of who is going to manage your finances if you become incapacitated and who is going to manage things if you pass away and where everything goes. The benefit of a trust is that it is something administered generally in a lawyer's office and not through court. So it can cost a lot less to do that.
Mm-hmm.
So usually we do both. We do a trust, and then we also do a will. The will is kind of that belt and suspenders approach to make sure that if something happens and it wasn't in the trust, we still know where it's going to go.
Okay. Okay.
And then the power of attorney is another document because as you talk through various assets, sometimes you have things that because of tax reasons don't go into a trust, or you need to be able to call your mother's social security or credit card account, and that's a power of attorney. So together, all three documents are going to allow whoever you select to make the financial decisions for you as needed.
And so aside from the benefit of these documents being that the estate will not go into probate, and let's pause for a second right there. So a lot of people think, well, I need to have $1 million home and $1 million in investments to make it worth it to have a trust. But can you offer some clarification around that? When should somebody have a trust?
I would say if they have a piece of real estate of any value, or
Mm-hmm.
more than about $150,000 in assets that don't have a beneficiary designation.
Okay.
So, even a $600,000 or $700,000 house, that is the value is calculated on the gross of the house. We do not look at the mortgage. And so the way it works is you end up spending, $9,000, $10,000 just to probate that one simple house. And you can easily put a comprehensive estate plan in place for a fraction of that cost.
Mm-hmm.
One thing to point out is there's a lot of people who will say, well, hey, there's this new thing in California. It's called a transfer on death deed. And it allows you to essentially put a beneficiary designation on the house. And that is a really poor planning tool in my experience. I've done a couple of them and they just don't work very well because it doesn't contemplate, minors that might need to inherit, or what happens if somebody has special needs or is not good with money. And so I really discourage people from using that tool and instead focus on a trust-based estate plan.
Okay, a trust-based estate plan. And so back to kind of where I have all these thoughts because I just know from the experience of dealing with families and, the attorneys that I know, it is so important. It's crucial to do this planning the right way. So what is another benefit of having this trust aside from the fact that you can avoid probate? From my experience dealing directly with families, when, an elder passes, what I have found is if there is a very well done trust, detailing exactly how everything is supposed to be, it really cuts down on the fights. I'm just going to say it like it is. It cuts down on the fighting amongst the siblings and the other family members has been my experience with it.
I agree. And also logistically, it makes it easier because for some reason, if you roll into the bank with a trust document and you say, I'm trustee for my mom, even if that trust is 10, 15 years old, the bank will accept you and deal with you and let you act as trustee. But if you go in with a power of attorney, powers of attorney are just so vulnerable to fraud that if it's older than a few years, oftentimes the banks will not talk to you. And so then they say something like, well, Sarah, I would accept this if your mom had signed it a year ago. You go, well, she didn't, and now she doesn't have capacity. And then you're stuck. Or they say, you know what, this is a great document that your attorney drafted, but the policy at Bank of America is that you have to use our specific form or else it doesn't work. And so things like that can really throw up barriers. And I think it's important to have an attorney that you can rely on so that if you get those kind of answers from institutions, somebody like myself can call and work through it. Because if you just do a form online because you think, oh, this is easy, I'm going to fill it out, then you don't have that person to, rely on.
To advocate for them, because you're dealing with this with so many different people. I mean, your level of expertise is much higher, and that's not insulting to any family members or anything. It's just, this is what you do for your job. So before we move on to the next question, people can go ahead and do the trust documents all day long, but what is the importance of funding the trust? And can you explain to the audience what that means?
So you can have the best written trust in the world with the power of attorney, your healthcare directives, and everything. But you think about this trust as an empty shell until you put stuff in it. And so putting stuff in your trust is what we call funding. That piece goes where you take your house from being owned by Sarah to retitle it to Sarah's trust. It's very important that you do that. Same with your bank accounts. You want to make sure that you're directing everything appropriately through titling and beneficiary designations, because if you don't do that, the trust doesn't do any good.
It's just an empty shell, right?
It is an empty shell. And there's attorneys out there that don't do funding. And it just boggles my mind that this client is coming to you for your expertise and you tell them, oh, go retitle your house. They don't know how to do that. Plus, it kind of sets them up for failure because they don't know what they don't know. And so it's very important that you check your assets on a regular basis and make sure they're properly funded to that trust.
Right. And I think that what I've seen lots of times is that one, it's not, maybe they don't know exactly how to do it. So they keep delaying and keep thinking, well, I'll take the time to figure out how to get this done. And then it's like with so many other things in life, right? Next thing you know, a month goes by, 5 years go by, 10 years go by. And then here's this, beautifully drafted trust with nothing in it. And so I do like to, that was great to hear you say that. So it sounds like you guys have some sort of process in place to ensure that the funding gets done.
We do, yes.
Okay, that's
and we
great.
often are reaching out with their advisors, right? So if you tell me, your financial advisor is, Sally, I'm going to call Sally and say, hey, Sally, Sarah and I completed her estate plan. Let's talk about her assets so that I can properly direct you on how I want these things updated. And that way we have a team in place to make sure that it's done properly. Now, there's probably going to be a few assets that maybe Sally doesn't manage that I'll help you with. But it's important because the professionals, I know people are so scared to use professionals. They don't want to pay the fees. But in the long run, it really makes sense. People ask me a lot, why don't I just do this trust on LegalZoom? And I explain to them that, LegalZoom is great. And I could write a very good trust by going through LegalZoom. But that's because when I'm presented with the question, I understand the legal ramifications between A, B, C, and D, and I can think through using my experience to know which is right for you.
Right.
And so I really do try and discourage people from doing things like that without the assistance of a professional, because a little bit of money up front is going to have your back if there's issues and save in the long run.
And that is so true. I mean, so many business owners I know that started out initially in business, tried to do it for themselves. It ends up backfiring at some point in time. So for everyone listening, when it comes to doing stuff for your business, please use an attorney. When it comes to, doing your estate planning, your trust, your power of attorneys, please reach out to an estate planning attorney. Okay, next question. So I hear this a lot, actually. So I was impressed that you posed this as something that we should talk about. So you'll often hear people say, well, can't I just have my parents add my name to the title of their house and bank account, and, I wouldn't need any of these estate planning or trust documents?
So that is a question I get a lot. And there are a lot of reasons why you shouldn't do that. But here's kind of the main one. Okay, so mom and dad have this adult son. He's 40, he's the light of their life, and he's a perfect angel, and he's married with 3 kids, and he's a great guy. So unfortunately, son does some bad business deals, and maybe he has to file for bankruptcy. And now mom and dad's house are impacted. Of course, the wife then leaves him because of these bad decisions. And now the wife is saying, well, hey, your name's on that house too. I need my share of it because we're in a community property state. Or God forbid, your son turns against you and you have a poor relationship. And mom and dad now need to maybe get a reverse mortgage because they need some money. I'm a big fan of those reverse mortgages because it's their money and they should use it. And the ones that save it for their ungrateful kids are just not doing the best for themselves, right? So let's say
I
they
see this all the time. And because I've been doing this for so long, advising families, it's really easy for me to identify at this point when it's really a matter of, okay, you say you want what's best for mom and dad, and they come up with all, there's the right time to have a reverse mortgage, and there's times where it's not the best option, right? But it is an option. And so it's really easy to recognize when the reason why the adult children don't want it to happen is because they just want to ensure that they get the house upon the parent's death. And so since we're talking about that, big shout out to Pete Tentler. I know you know Pete too. He's going to come on here soon. So he is, what's he call himself? The financial locksmith?
That's right. He will unlock the equity in your house, right? So I'm talking to mom and dad and I say, hey, mom and dad, you know what? You could really ease your cash flow if you just got a reverse mortgage. And they go, oh, that's a great idea. So I introduce them to Pete, and Pete talks to them and decide it's a great idea. And then we discover that son is on the mortgage, or son is on the house. So what does that mean? That means they have to get him off. That means he's got to be, a willing participant in this. And son is like, well, no, mom and dad, you don't need it. You have plenty of money. And so something like that can be a barrier to what the parents need.
Especially when they need money for their care, right? Maybe they don't want to leave their home and go into an assisted living facility, and they can unlock the money from their home to be able to pay for care. I have not even thought about this scenario before, Danielle, where the adult child is actually on the house. Do you find that that's more common than what people want to think?
Yeah, I do. They think it's an easy, planning tool. And it doesn't work if, let's say something happens to the adult child and now he's stuck getting the house, and maybe that wasn't the right thing because maybe he's on Medi-Cal or SSI or, something like that. It's just an irrevocable kind of designation. I mean, I talked to somebody this week who has 2 boys, they're twins, and one is great and the other one won't speak to her. And, she put together something that was irrevocable 20 years ago. And I was like, there's nothing I can do. I can't even go to court and try and get him off because you already made the gift. It's too late. And so once you add your kid to your house, it's too late if people don't agree to change it.
So are you saying that's an irrevocable decision, or what is that? Because I hear the term irrevocable trust all the time. So not that you have to give everybody a legal lesson right now, but what is the difference between an irrevocable trust and then the other sorts of trust that you're talking about doing that would put everything into the trust for the home and the assets?
Your typical estate plan, the foundational estate plan, is a revocable trust. We call it a living trust, a family trust, a revocable trust. And it's something that you can amend from time to time as the circumstances warrant. So let's say that you've got some kids and you're going to leave everything to them. A couple of years goes by and you realize that maybe they're not the best with money. And so you want to make some updates, and you can do that. When you pass away, your trust becomes irrevocable. Nobody can come behind you and change it.
Okay.
So when you make a gift to somebody, when I go ahead and add you to my house, Sarah, there's no way for me to take that back unilaterally. I would have to agree, and you have to agree to give it back to me. So in my mind, that's like an irrevocable decision. Once you've given it away, it's gone. And one of my mentors used to use the term about toothpaste. Once the toothpaste comes out of the tube, it's not going back.
I feel like I've heard that before. I don't know if you've said that before in one of the meetings that we've been in, or if I heard it from your mentor maybe, but I have definitely heard that before. Let's see. Do you have any tips on how to make sure that the adult child or whomever the person has the planning has the information needed to take over their parents' finances if they become unable to? And this is for everybody listening, this is super important because in the last couple of weeks, I've run into 2 situations where this has become a serious issue. So what are the tips to make sure that they have access to the information to take over finances if their parent becomes incapable?
So that's a really good question, because a lot of people are, secretive about what they have. They don't want to talk about money. When they grew up in their home, money was kind of taboo. And so it's uncomfortable for mom and dad to sit down with you and say exactly what they have. And so having some sort of family meeting with a level of disclosure that everybody's comfortable with is great. I don't know that I need to know to the dollar what is in my mother's bank account, but if I know that she banks with Fidelity and Vanguard and where I can find that information in her house if something happens, that would be ideal.
Mhm.
So I have a personal information worksheet that anybody who wants it, I'm happy to share it for free. You just have to email me. And it's about 9 pages and it fills out all this stuff that's in my head that I would write down. It's got information on where my kids live, where my pets go to the vet, which companies hold all my insurance policies, what's the combination to my safe, all those
Mm.
kind of things. And ideally, you fill it out and you give it to your trustee. If you don't want to do that, you fill it out and you keep it somewhere with details on how they can access it. Because the days of just monitoring mom's mail for a few months to figure out everything are over. A lot of
Ugh.
things are done electronically. And so family meetings, communication, writing things down so that they have all the keys to the castle is going to really make sure that there's a seamless transition if it's needed.
Yes. And do you help facilitate any sort of these family meetings that you're talking about? Is that part of your practice?
It is. And now it's great because with the adoption of Zoom, I can do them very easily. It used to be that every Thanksgiving and Christmas break, I'd always have a couple because the kids are home and it's a good time to do it.
Yeah.
But now with Zoom, we can do it now. And I talk to my clients ahead of time about what level of disclosure they're comfortable with.
Hmm.
And then I can facilitate, that meeting. I
Hmm.
was writing an agenda for a family meeting just a couple days ago because a client came to me and said, you know what, I'm having trouble. My siblings, the three of them, and I are all co-trustees. Bad idea. That attorney should not have done that. And
Oh,
they don't get along. And so what's happened is they're in a kind of a purgatory where mom needs help, mom can't get it because nobody will agree.
I
And
see
so
that so much.
exactly. So I was writing like an agenda for them to conduct a family meeting because if I come in initially, it kind of looks a little combative or aggressive. So instead, behind the scenes, I'm writing that agenda. But in a typical planning context, I'm oftentimes facilitating those meetings.
Okay, that's really good to know. So here's our last question, and then I want to make sure that we provide information for people to reach out to you if they want to learn more about how you can help them. Um, how often should people review their documents, whether they need to be changed or not? But how often should somebody review them?
The term of 3 years seems to be a very comfortable term. Now, I have clients that, call me every 6 months and make changes. But if at least every 3 years you have a meeting with your attorney, 20, 30 minutes to just kind of go over the highlights of what it is, even if there's not any changes to the documents needed, usually I still discover an asset that maybe wasn't funded, or maybe there's an issue that they wouldn't have called me proactively about, but I can help through. So I would say 3 years is a good time to review it. If any of you out there have trusts from the 90s or the 2000s, if you're married, it's very important that you look at them. A lot of the planning language that was done at that time is not ideal for our current tax climate. So it's really good to look at those, kind of things. If you had a trust with your deceased wife and you got married 5 or 6 years ago, you probably should see me.
I have seen that. I have had clients over the years where, let's just say it's the husband, okay? He passes away, and then all of a sudden the family discovers that he had some, I don't know, 401k or some asset, right? That was still, the beneficiary was still the ex-wife from 20 years ago.
Mhm.
Anyway, yeah, it's people review your documents, call Danielle, have them reviewed every 3 years, if not every year. If there's any major life changes, it is super, super important because I've seen the effects of it not being done and it's not pretty. So we do have a comment. Let's see what it says. So I can't see who made this comment, but they said, this is important. and it says, I have more than once dealt with a POA who did not understand the limits of their authority over my patient.
Yeah, it's important to select agents that are trustworthy, that you know are going to make the right decisions. For example, there's powers of attorney out there that might give powers to make gifts of money. That's a clause that I sometimes see that I don't personally like. I don't like the ability to have me appoint my agent who can then use my money and make gifts for themselves. So again, it's important to have an attorney, whether it's me or other people in town. There's some great attorneys in town, so that you have somebody to go to, so that if there's a concern that the power of attorney is exceeding their authority or not doing the right thing, you can get that kind of guidance.
Absolutely. So Danielle, for those of people watching, if they are thinking, geez, I really need to call Danielle and have my documents reviewed, or maybe they don't have any planning in place at all, and we've been able to get through to them the importance of it, how can they reach you?
So probably reaching out on my website is a great way to connect.
Okay.
So I'm Danielle Barger, and my partner is Danny Battiest. So together we are DB squared. So my website is www.db, the word squared, law.com. DBSQUARED law.com. And it's got all my information, my biography, ways to contact us, and everything.
Okay, and I will be reposting your website when I go ahead and send this out too. Well, everyone, thank you for joining us today. As a reminder, my name is Sarah Barker, and my company is Connect Our Elders. Our entire focus is to provide education around elder care resources, to provide the navigation through those resources, and to offer ongoing advocacy. Thank you for joining us today, and thank you, Danielle.
Thank you.